You've seen videos of cops executing warrants at the wrong home before. It's a nightmare scenario, one of the most dangerous encounters we can have with our government. Police want the ability to come into our house with a team of men dressed and equipped like soldiers. But they also want to do so in an environment of total immunity so that they can't be sued when they make mistakes or act recklessly. This just happened in Joliet, Illinois, where law enforcement invaded the wrong home. It also recently happened to my client here in West Virginia. They came home to find cops on their surveillance footage walking around inside their home, guns drawn.
Police! Front door's open! You're behind me. Police!
What happens when the police invade the wrong home? Can you sue them, or can they get away with it? I'll show you two different cases here. One that just hit the news in Joliet, Illinois, and the other right here in West Virginia with footage that you have never seen before. In the early morning hours of November 2nd, 2021, 22 police officers gathered outside a two-family residential building at 226 and 228 South Comstock, Joliet, Illinois, in preparation to execute an arrest warrant for one Elian J. Raya at 226 South Comstock. I saw this in the news where they had just filed a lawsuit, and I reached out to their lawyer, and he kindly provided me with the original ring footage. Here it is. The officers split into two groups. About 14 of them remained in front of the building. The others went to the rear. But inexplicably, rather than approach the front door that had the 226 sign on the wall next to it, the group of officers in the front of the building instead approached the front door with the 228 sign on the wall next to it. And then they proceeded to execute the arrest warrant at 228 South Comstock instead of 226 South Comstock, where they had a warrant for. Adela Carrasco was sleeping in her bedroom in the 228 residence when she was suddenly awakened by the booming sound of yelling and banging on her front door. She got out of bed and she went to the top of the stairs leading to her front door, where she called out and asked who was at the door. Outside her door, the officers shouted that it was the U.S. Marshals and the Joliet Police Department and that they had a warrant for Elliot Reyes. Nowhere on the arrest warrant for Elian J. Raya did the name Elliot Reyes appear. Meanwhile, here in West Virginia, this family comes home to find a police officer's card inside their home. They check their surveillance cameras that are inside their home, and they see tactically dressed police officers inside their home, including in their child's bedroom, pointing guns and going through all their stuff. Take a look at this.
Police! Front door's open! You're behind me. Police! Clear. Moving. All right. Police, anybody here? Clear. Coming out. Everybody getting moved. Clear place. All right. Blue going in. You need another body? Yeah, come down here real quick, please. Put his bathroom on the floor. Over here. That's not her. Okay. Police, anybody here? Got a big room left and big room right. All right. Yep. Yeah, come down here real quick, please. Go to the bathroom. Over here. I think that's what we're in. What's her name? Laurel Wolf.
Shannon McClure.
We have a
Shannon Wickline.
we have a Jason Wickline up in the mailbox. Oh, I think they moved.
Shannon Wickline?
That's what the mail is here.
Mm.
Well, whose picture is that right there? That's not her, is it?
Can't really tell.
Hey, there's a camera right there.
You want to leave a business card in the middle?
A basic principle of Fourth Amendment law is that searches and seizures inside a home without a warrant are presumptively unreasonable. But a warrantless search of a home based on an officer's mistake does not violate the Fourth Amendment where the officer's conduct was consistent with a reasonable effort to ascertain and identify the place intended to be searched within the meaning of the Fourth Amendment. In Garrison, the Supreme Court considered the constitutionality of an accidental search of the wrong apartment. There, officers obtained a search warrant for the third-floor apartment of a particular complex, and when the police applied for the warrant and conducted the search, they reasonably believed that there was only one third-floor apartment, and that was based on the verification of information obtained from a reliable informant, an exterior examination of the three-story building, and an inquiry of the utility company. Those were the facts of that case. In fact, there were two different apartments on the third floor of that complex, and then the police officers began searching the wrong one while executing the warrant and then found illegal drugs. The Supreme Court held that the officer's conduct was consistent with a reasonable effort to ascertain and identify the place intended to be searched within the meaning of the Fourth Amendment. The court further explained, however, that if the officers had known or should have known that the third floor contained two apartments before they entered the living quarters on the third floor, and thus had been aware of the error in the warrant, they would have been obligated to limit their search to the target apartment. Therefore, according to the Garrison case, the law is clearly established that absent probable cause and exigent circumstances, a warrantless search of a residence violates the Fourth Amendment unless the officers engage in reasonable efforts to avoid error. Thus, an officer who does nothing to make sure that he was leading other officers to the correct residence to execute a search warrant is not going to be entitled to qualified immunity under Garrison. But courts have held that they will allow some latitude for honest mistakes that are made by officers in the, quote, dangerous and difficult process of making arrests and executing search warrants. However, they must be consistent with a reasonable effort to ascertain and identify the correct place to be searched, as dictated by the Garrison case. So the issue is not whether or not it's the wrong address. We all know that in both of these instances, we're talking about the wrong address, a different one that was listed on the warrant. The issue then becomes a factual analysis of whether the officer or officers made reasonable efforts to ascertain and execute the warrant at the correct location. So we have to dig into the facts. First, the West Virginia case. In this particular case, I believe that the officers did not make reasonable efforts, and here's why. So the search that you see on the video happened on December 15th of this particular year, almost 2 years ago. But that wasn't the first action that they took. In fact, back on November 7th of that year, the Kanawha County Sheriff's Department shows up with like 10 deputies, and they surround the house looking for this woman named Laurel Wolf. But my clients had lived at this address for 2 years. This woman didn't live there. All they said was that this was her last known address as of like 5 years ago. Then they visited a second time on November 8th. That was during the day at some point, and they were again told that she didn't live at that house anymore. And so they come again November 8th, later that evening. Again, they're looking for the same woman. She doesn't live there. They were told that she doesn't live there. So this woman, meanwhile, on November 24th, gets arrested. She's held in jail for a week and then bonds out. So she's arrested. But then, for some reason, inexplicably, again, just like the other case, December 15th, all these cops show up and they come in the house. They say that the door is open, but it was not open. They come in, guns drawn, and here we see marshals, or U.S. Marshals, but the card that was left was, again, a Kanawha County deputy. So to a certain extent, they may have been acting like a task force, as in the case in Joliet. So as in the other case, we're dealing with a family with children, completely innocent, wrong address. Were there any reasonable efforts taken to ascertain this was the correct address? I don't believe the facts in the West Virginia case hold up to that. And what about the Joliet, Illinois case? Actually, those facts line up very well with the facts in Garrison. It is the same structure. It's a multi-family or multi-apartment structure. And the cops in Garrison, even though they did their due diligence, I think there were 3 different sources, they, at least the court found, did not discover that there was another family living there. Whereas if you read the lawsuit details, and I'll post it up at the blog post link below at thecivilrightslawyer.com, you can read the lawsuit for yourself, but it appears that the officer who applied for and obtained the search warrant was aware of the fact that the guy who was the subject of the warrant had a brother, and he suspected this brother might know something about the shooting on Halloween, might have been involved in some gang activity, and was sort of hoping, the allegations were, that the police officers he was bringing would kind of spill over into the apartment next door where the brother was living. And so it wasn't a total accident. Some of the officers may not have known, but the guy who organized the whole thing, according to the allegations, he knew that it was just the 226 that was the target of the warrant, but that next door in the same building in 228, that brother lived there, and he didn't have probable cause to get a warrant for him, but was kind of hoping that they might accidentally grab him, might accidentally find something on him during the search. So that fits very well within the fact pattern of Garrison to show it was not a reasonable mistake. Reasonable efforts were not made to sort of inform the other officers that, look, this is multifamily and the guy we're looking for is in 226. These are 2 different fact patterns, but I think we have liability in both of these cases. But you take those good facts out, and if the courts were to find that it was a reasonable mistake, that they made, they engaged in reasonable efforts to identify the right address, then what's going to happen? The courts are going to grant qualified immunity to the officers. Basically, a reasonable mistake. Basically, it depends on the facts. So thanks for watching. As always, if you like looking at these cases and then going over the constitutional law and making sure that we understand it, please subscribe both here and at the blog at thecivilrightslawyer.com. I will definitely update my case. Let me know in the comments what you think, and if you think that a lawsuit should be filed in this case. I'll also try to follow along with the Joliet case and provide you an update on that as well. Remember, my freedom does not end where your fear begins. Freedom is scary. Deal with it.